So this is a bill that was discussed by the committee extensively last night. There is a new amendment, which should have been on your chair when you came in. This is a less extensive amendment than the one that was considered last night, and it would really do two things to the bill. First, it would strike language in the bill that states the findings of the General Assembly, and second, it would insert in the provisions that were discussed last night, which would prohibit essentially law enforcement agents in the field from performing immigration tasks. Though I would call the committee's attention to a couple of changes to that language from what was considered last night. So if you turn to page 5 of the reprint, in subsection A5, there's a new definition of law enforcement agent, which was crafted to ensure that this prohibition doesn't cover anybody who's working in a correctional facility. So law enforcement agent would now be defined as an individual who is certified by the Police Training and Standards Commission and would not include an agent or employee of a state or local correctional facility. And the other change to the language is in subsection B1, where it clarifies that arrest does not include a routine booking procedure in a state or local correctional facility. So that was to ensure that the normal booking process could proceed the same as it does now.
Senator Sidnor.
Thank you, Mr. Chair. I'd like to commend council because it looks as if the things that were mentioned last night as being problematic about last night's bill, he's addressed the issues. Now, from what I see, when someone is stopped in the field, they won't be subjected to those types of questions. However, the issue last night was about them figuring out who they were. Well, when they're brought into prison to be booked, there's no prohibition to asking certain questions. So I think he did fabulous in addressing the concerns that were raised last night, and I would move the bill.
Let's go ahead and let's adopt the amendments first. So is everyone okay adopt the amendments? All right, excellent. This is what we're working off of. So that we've done that. So then you got to make another motion to do that again. But yeah, we got Senator Huff and then Senator Castley, and we'll go back to Senator Sidnor or Senator Lee.
Well, all right. Just I know people are in a rush, but this is a big bill, so I want to make sure I understand it. So everything with detainers that we discussed last night is now out of the bill, correct? All right. How does this affect counties that have a 287G program?
287G programs would not be affected as they're currently constructed. What's being added to the bill applies only to police officers in the field performing those regular functions and does not affect anything that goes on in a correctional facility.
So it doesn't affect the counties that currently, the couple that are being paid for holding?
Only to the extent that they're doing so pursuant to a detainer. If they're doing general immigration detention, where they're holding people who are going through immigration proceedings on a semi-permanent basis, that would be prohibited by the provisions of the bill as it came in.
Yeah, so if you have that's my understanding, is if, I guess these folks are on the detainer, that's what's confusing to me, is that they are holding them locally, and I know Frederick County is getting reimbursed for holding them. So you're saying that they would no longer be able to, if they're on a detainer, so no matter what they come in on a detainer, they can hold them. That's not the issue anymore. But I thought locally, even like our county was holding people,
right?
And
So
being reimbursed.
The distinction is in the detainer situation, the situation where the local jurisdiction has arrested and detained an individual on suspicion of criminal activity, and they inform ICE about that, and ICE sends a request which says, hold them for, another day or two before you release them so we can come and pick them up and take them into our custody. So that's the detainer. The immigration detention agreement would be where ICE has already arrested an individual and placed them into deportation proceedings, and they're going to be detained for the duration of their immigration case, and that is where they would be housed in those local facilities on that kind of semi-permanent basis.
Yeah, so got it. So if you pick up somebody, let's say ICE picks up somebody in Prince George's County, if you say that no one in Maryland is going to hold them, so you say that instead of them being held in Frederick County or wherever, they'd have to be held out of state now at this point, correct?
That's correct. Or they could be held if there was a private facility where the requirements of the bill were complied with. They could be held in that facility, but they could not be held in a public facility in the state, no.
Well, I just find it an interesting bill then. So we have in front of us, if somebody's picked up in Maryland, it's always told to me that you're better off to be near your family, near your attorneys, near where you live, versus getting shipped off to maybe a red state in Maryland, or not Maryland, a red state in America that would be very happy to take the federal money and house people, and maybe going down to Tennessee or something like that, versus being held in Harford County or Frederick County. So I don't know why that's a better policy. And the second part that I find interesting is that rather being held in a public jail, I've always thought that progressives were against private prisons. So this would say that they could now come to Frederick County and the federal government could build a private facility and a private prison and put them in a private prison. So I just find that very interesting to me that, A, the outcome is we're going to ship people from Maryland out of state, which is bad for them. B, it says, well, don't hold them in the county jail, which is run by our elected officials. Let's hold them in a private prison that the federal government sets up, which I always thought progressives were against private prisons. We never have them in Maryland. I never really had a position on them. I always thought the public ones are better. But I don't know why we would pass this. Like, why do we think this is good policy?
So a couple things. First, for the initial piece that you're talking about, for the jurisdictions that have the 287G program, you still be able to do that in that 48-hour communication and hold. This is for long-term, basically long-term people that have been awaiting their immigration, disposition, and deportation procedures. Second, for the private police, obviously you hit it right. The federal government could contract with some private enterprise to build something in Maryland, but it requires a full analysis and public hearing and vetting from the community. The community has an opportunity to organize against this type of an enterprise coming into their community. So that's what this bill would do. Third, the testimony, which we had a lot more in the House than the Senate, is that, look, a lot of the families are terrified and just simply don't go and visit their family members, even if they're housed locally. And so the purpose of the bill is to establish those kind of bright line policy objectives of not having those types of facilities in our state anywhere, and ensuring that the local jurisdictions that have now rented their space out, do not engage in that practice in the future. So, Senator Sidnor, and then we'll go back to Senator Castley.
No, again, I'd just like to move the bill as amended.
Sorry. May I be added as a sponsor? Co-sponsor? May I be added as a co-sponsor?
As well, please. Thank you. So I have a question for the senators in law enforcement. So yesterday we were dealing with this issue of establishing identity. And so that starts on page 5, the Criminal Procedure Article 5104, 505 of the reprint, and onto the page after 505 on the reprint. And so I just want to understand, I appreciate what the senator from Baltimore City and Baltimore County said, but I just want to make sure before we move forward that your concerns from yesterday are assuaged in those sections, because I don't see what was added from yesterday, unless I'm missing something.
So I have to say that is why my light is on. I know, Josh, you said that it was covered, but when at the top of, the page after the top of 505, if you look at the second paragraph, the second sentence down, inquire about an individual's citizenship, immigration status, or place of birth during a stop, a search, or an arrest. Right? You're still going to have to do that. I don't see, you said you very eloquently at the beginning said that that's not part of it. There was an amendment for that, but I don't see where that is.
Change was on the previous page in subsection B1. It simply clarifies that arrest does not include a routine booking procedure in a state or local correctional facility. So it simply states that the arrest does not continue to where they're being booked.
What about in the field?
It-
How do you establish identity in the field, I guess, is what.
You would still be prohibited from asking about those things in the field, yes.
Senator Jackson.
Could you say that again, John? Could you say that again? You said arrests?
If you go to the bottom of page 5.
Right. Okay.
You
Does
see
that
the
include
last.
routine booking procedure in
Yeah.
a state correctional facility or a local correctional facility?
All right, Senator West.
I think
As you know, I wasn't here last night, so I didn't benefit from the conversation, but let me just give you a hypothetical and find out how this bill would handle that. So someone is arrested for a crime in Maryland, rape, armed robbery, something else, and is taken into the booking facility. Would this bill prevent the law enforcement authorities from contacting ICE and telling ICE that we have a person here arrested for a crime who we believe is an illegal immigrant?
No, it would not. I mean, you weren't here, but as opposed to the amendment last night, this amendment would basically take out anything that deals with what happens in a correctional facility.
Okay, thank you.
All right, it's been seconded. All right, Senator Jackson and then Bailey.
I'll defer to Senator Bailey.
So I'm just going to explain to you, right up the street here is the tallest building. Right there, when you go in the tallest building, between the Court of Appeals and the tallest building, and if you go on the bottom floor, there's a detention facility there. It's the Natural Resource Police holding cell. If there's an arrest made anywhere up here in this area, those officers would go into that basement with that arrestee because it wouldn't take him directly from where it was to there. They would process that person. They would do the fingerprints right there as a police officer, right? Then they would go over to the detention facility, pull in the Sally Port, and they would turn the fingerprints over and the defendant right there to them. The fingerprint cards and everything would already be filled out. Now, I have been gone a couple years from there. But what I'm saying very clearly is you have put that officer in the trick pot by the top of page 6, that number 1 that says inquire about individual citizenship, immigration status, or place of birth during a stop, a search, or an arrest. So that, the scenario I think that you could probably get away with is during a stop or a search. But when you have an arrest, that officer is definitely required, right? That person is definitely required to determine who that person is. And so, I mean, I'm just saying, Senator asked for clarity about that, and that's what I'm just pointing out, that you are definitely putting. But now there's no doubt about it, with some of the bigger police departments that exist in this state that have direct relationship with county facilities and detention centers, they operate differently. The scenario that you played out would work for them, but for the smaller municipalities and the state facilities that do not have that, if you were to go to the state police barrack, right? They do their fingerprint cards at the state police barrack on every arrest they do. Then they take those person to the county detention centers. This number 1 up here, or little 1, would definitely, or whatever it is, would be a issue and a problem.
Is there any way, Mr. Chairman, we can either strike arrest or
Addition, I think the language below, the bottom of page 5, is more than sufficient to address those concerns. What is your, I'm not understanding the question.
It's a
Sorry.
processing, it's a processing concern, so,
You-
I'm sorry, so, Mr. Chairman, it's a processing concern for some of the agencies in the state. They must do as part of their procedures, policies and procedures, that they must fingerprint a person that they've arrested. And so for federal government and every other agency, state and federal partners, you must ask those particular questions just for the fingerprint card. That's the first thing that happens when you come through the door. Yeah, yeah.
That's taken out of what an arrest is, and according to Section B1.
Yeah, I think the concern is, if that qualifies for what Senator Bailey just mentioned,
So how is that, what,
It
just,
says in a state, local correctional
Can you get Bailey?
facility or a local correctional facility. So in a detention center, what you're saying is exactly right. But if you go right up here to J Barrack, or you go to the natural resource building right down to the Talls building right there, they are not state or county correctional facilities. That's where the fingerprints are done. That's where they do it. Those officers are in the trick bag.
how about we say, do we say processing or
Senator Sidnor.
So what you're saying is we need to broaden the facilities, so we include those types of facilities. And if that's the case, then we're good.
Right. I'm just, I'm not opposed.
Oh, no, I got you.
Right, I'm just
I hear
saying
you.
these guys are in a trick bag if we let it go the way the wording is.
Got you. Thank you.
Well, we did try to knock out the world arrest. Yeah. So I think the easiest way to do it is to make a motion to just knock out on the top of page 6, after search, where it says knockout or an arrest.
He's on page.
Counsel, go ahead.
Thank you. Just in listening to the question that was okay, I'm sorry.
So Senator Bailey, do you think the concern would be addressed if on page 5, in subsection B1, you simply struck in a state correctional facility or a local correctional facility, so it would read, arrest does not include a routine booking procedure, so it would be independent of where that procedure takes place?
That would alleviate the problem. Yeah, and I do appreciate that.
Everyone okay with that amendment? Great. Senator Sidnor.
We press the motion. Very good.
Understood this thing about detention. So let me ask the two police officers in our midst. So someone is being held in jail, and the time when they're supposed to be held is approaching its end, and you know the end date is Wednesday. What would stop, and what this is to try to prevent, is for the person being held beyond Wednesday to wait for the ICE people to arrive, right? What's that?
Not touch any of those procedures.
I'm looking at the second part, detain or prolong the detention of an individual. Isn't that what I'm
What
talking
page are you on?
What's that?
What page are you on?
I'm on page 6, or the page after page 5, and about lines 5 and 6.
Those provisions deal with law enforcement agents, and the definition of law enforcement agent specifically excludes agents or employees of correctional facilities. So it would not apply in a situation where the person is in a correctional facility being detained by correctional staff.
All right, well, what would it apply to then?
It would apply to police officers in the field performing.
Oh, in the
police-
field, somebody out there that stops somebody at the side of the road?
Correct, and they
I
might
got
say,
you. All
yeah,
right, fine.
can I hold you a little longer to call ICE or something like
Yeah,
that?
okay, fine. Got you.
Yes, understood. All right. And then we've got a motion's been seconded.
All right, so you're talking about because it doesn't have anything to do with detainers. It's a detainer's been lodged. A detainer's been lodged. ICE has picked up the person. So that's what the portion of this bill deals with. ICE has picked them up, and then they want to house them in let's say, one of our county jails. That's what we're talking about, those people. So we passed this bill. Somebody's picked up in Prince George's County. They're held on a detainer there. ICE picks them up, and they're saying, hey, let's hold them in Montgomery or Frederick County or wherever. We got an agreement with the local jail. Now, because we passed this bill, they say, nope, can't hold them anywhere in Maryland. So they got to go, all right, well, we got to send them down to Tennessee because they're going to hold them. So we're taking people who are, they could have been living in the community of Prince George's County for 20 years, and somehow we think by sending them out to Knoxville, Tennessee, that's a better policy for them, as if it'll be friendlier and better for them and their family to go visit them in Knoxville, Tennessee, and their defense attorney. That's a bad policy. Number two, you would much rather have people, in my opinion, incarcerated and held in one of our public facilities, which is under our public laws, under the laws that we pass here, under our elected officials, folks like us. This bill says you can get around all of it if you go have a zoning hearing in Garrett County, and then they build a private facility, which is completely under the federal rules and whatever the private prison people want to do. It's not under our public safety article, not under our corrections article, nothing. Cuts us out. This policy makes no sense. Y'all want to pass it, that's up to you, but I'm just astounded to watch a bunch, people that fashion themselves as progressive on crime for a bill to send people to a bunch of red states that'll hold them and send them into private prisons in Maryland. I don't know why that would make any sense.
Thank you, Mr. Chairman. Two things. One is I just want to reiterate something you said earlier about the building of private prisons, for which we are fortunate not to have any in Maryland, and there would have to be quite a public community input process for there to be any, first of all. And second of all, I think as self-proclaimed progressive, I would urge us to listen to the people for whom this affects, who have been very clear that they do not want people held in the state of Maryland. So for the people who are most directly affected, they have stated this very clearly, and I think it is only respectful to listen to the people who are most directly affected by this and the families who experience these processes with them. Thank you.
Okay, so there's been a motion. Seconded. We'll do a roll call.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Casserly.
No.
Senator Heddleman.
Yes.
Senator West.
No.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
I'm going to vote no, but I do want everyone on here to understand how much I appreciate them working to make this better for the officers that are out there in the street dealing with people. And I think that the amendment that we put forward will help, and it will clear up any problem or potential.
Senator Carter.
Yes.
Senator Huff.
No.
Chairman Smith.
Yes.
Bill passes favorable with amendment.
Bill passes. To conform the House bill, which is House Bill 16 to what we just did here. Is everyone okay? Recording their same vote? Great. All right. Now, Heather.
So House Bill 31, when you keep, oh, sure. So House Bill 31, when you came in, there was either an amendment that I handed you or it was sitting on your chair. So this is the current version of the amendments. So under this proposed amendment, the surcharge for the circuit court will increase from $55 up to $85. And the district court, everything except summary adjustment, will increase from $18 to $28. And then as proposed at the last voting session for this bill, there's also going to be a sunset provision regarding the summary adjustment. So if you look at section 1 of the bill on page 3, this is what the surcharges will look like after the sunset happens, or if the access to counsel bill does not pass. Then if you go to page, yes. You're welcome. And then if you go to page 8 of the reprint, and then this is the unnumbered line after line 13. This is section 2. So this is what the increases in the surcharges will look like during the 3-year period, assuming access to counsel passes. So for these 3 years, the summary adjustment will increase from $8 to $50 and will be distributed among the Access to Counsel Fund and the Maryland Legal Services Corporation. So $33 will go to Access to Counsel, $17 will go to the MLSC. And then if you look at the bottom of the unnumbered, or bottom of page 8, unnumbered lines, you see section 3. This is the provision that's prohibiting the landlord from passing the $50 surcharge onto the tenants. It also prohibits the landlord from specifying in a residential lease or in a complaint filed in district court requesting the $50 surcharge. And then if you flip to the final page of the reprint, which is unnumbered, this specifies that sections 2 and 3 of the bill, section 2 is the increased surcharges, including the summary adjustment surcharge, and section 3, which was the prohibition on passing the surcharge on, those will sunset after 3 years. So then section 1 will go into effect.
The fees go down as well. The fees and the pass-through go away.
So if you look at section 1 of the bill on page 3, this is what it will look like after the sunset happens or if access to counsel does not happen. So the circuit court surcharge will still be increased to $85. District court for everything except summary ejectments will be $28, but the summary ejectment surcharge will be $8.
And the pass-through is gone.
And the pass-through is gone.
Or the prohibition of the pass-through.
Excuse me, the prohibition.
Prohibition of the pass-through. All right. So Senator Lee, go ahead. Sorry.
Right. To the tenant?
So for 3 years, landlords cannot pass on the $50 charge. After the 3 years, or if access to counsel does not pass, the summary ejectment will be $8, and landlords can pass that on. So it's only for 3 years the landlords cannot pass on the summary ejectment, and that's when it's $50.
So
I can't hear you.
So the pass-through ban is only good for 3 years, you're saying? Yes. And then it comes back afterwards? Okay.
Yeah, I see an $8 surcharge. How's it $50? What am I missing? Oh, there you are. Sorry.
Yeah, so it's kind of confusing the way it's drafted because it's contingent on another bill and then also subject to a sunset. So what
I
you
just had
need
my
to,
sections misordered then. Okay.
so look at section 1 on page 3, and then you also need to look at the same time section 2 on page 8.
Okay, that's the
So
section.
if access to counsel passes.
No, I'm
Oh,
with you.
so you got it.
I thought that they were the other way around. I'm sorry. This is the contingent one is up front. The other one, I got you. I just misunderstood where the contingencies were. Okay. Can I just make another point before I, that was just a question. So, I mean, my concern remains how this might negatively impact the availability of rental housing for low-income tenements. And that if we mess up here and make that, there's all these initiatives out there to increase the rental market or the availability of rental units for low-income tenants. And if we screw up that market too much, that building that was lower income, the landlord can always just, if the numbers aren't right, they just close that out, revamp everything, upgrade all the upgrade stuff a little bit more, and then charge more for it, and don't cater to the low income market. So I'm very concerned, and so we're going to go through a 3-year experiment, at the end of which it may be too late. We may have already eliminated a lot of potential, or a lot of the lower income rental market. We may have screwed this up and forced changes we didn't intend to. So that's my first point. My second, I continue to take the position that we're putting this kind of money ought to come out of the general fund, because you're pushing stuff against people in court who have problems in life to pay for other people's legal services, and that's just not right. If you're going to take money for legal services for indigent folks, that doesn't come out of a surcharge on people who are in court with problems. That's just fundamentally not a good way to look at that. They shouldn't be looked as a revenue generating source. Their fees should just cover what they're using, not providing sort of a safety net to other indigent people who have nothing to do with their case. So that's my second point. And then third, that I just really reject this whole attitude that says that the landlords are using this as a debt collection. I mean, that they're serial filers, like serial killers. It's not. These are landlords when the entire process was created and the courts decided that we didn't want self-help in landlords. We wanted to get the courts involved. So we didn't have landlords pushing people out who maybe for the wrong reasons. So they said, no, you just can't do any self-help. We want you to come into court. In fact, we're only going to charge you $8 to get here. That's how much we want you to come in here. Bring your problems in here so that it's public, it's transparent. We can help the tenants out, make sure the tenant's not getting screwed. We can take this at a nice pace. So having done that, now we're saying, and that whole process told the landlords, yeah, the landlords say, you want us to come in every month? Yeah, come in every month. If they're not paying, just bring it every month. Now the landlords do that, and we say, you're serial filers and you're evil people, elite on society. They're just doing what the process that we set up to do. It's not like there's, you didn't pay, you come in. You didn't pay, you come in again. So the idea that we see this as some sort of public evil is just wrong. They're not. When you say, well, the landlord's trying to collect debt, well, the tenant's avoiding debt. I mean, the process is set up to give the tenant a much a better ability to control the landlord's actions. So every time we do these bills now, we have to demonize somebody. Somebody has to be evil, and we got to stomp out because they're morally deficient. They're morally. Everything has to be good guys versus bad guys. Not just good public policy. We're going to make somebody the bad guy, and then we're going to punish them and squash them. So I just think that the whole thing is really not a good way to go. But we really should be fearful of this 3-year sunset. Because this is a rather substantial hit, and it's going to change the dynamics. I'm sad. I'm sorry that we went from we deleted the provision here that said, well, on the first one you can't, but on subsequent ones you could. I think that was a major mistake to delete that in this amendment. That was a fair compromise on that. So thank you.
Thank you, Mr. Chair. I've got 2 amendments to propose. That's fine.
Documents, we can work off of this. All right, then, before you get to your amendment, let's go to Senator Sidnor.
Just one quick question. I was looking at section 5, and I know we were talking about the 3-year period. but I just wanted to make sure I was understanding it correctly. It says remain effective for a period of 3 years and at the end of October 1, 2023. Those sections won't be of any, I guess, of effect. Is okay. I just want.
Section 5. I kept thinking it was 2020. To be fair, it was the forgotten year.
The lost year.
Thank you, Mr. Chair. We've talked about this seemingly ad nauseum. I'd like to propose that in section, on the bottom of page 8 of 8, in section 3A, we provide that, and be further enacted that, we change the language to read, in any calendar year, the first surcharge assessed by the district court per summary ejectment case, et cetera, may not be passed on to a tenant by the court or by a landlord, semicolon, any subsequent surcharges may be passed on to a tenant by the court or a landlord.
Vice Chair Waldstraker.
No.
Senator Lee.
No.
Senator Castle.
Yes.
Senator Heddleman.
No.
Senator West.
Yes.
Senator Sidnor.
No.
Senator Jackson.
No.
Senator Bailey.
Yes.
Senator Carter.
No.
Senator Huff.
Yes.
Chairman Smith.
No.
Motion fails.
Motion fails. Okay, Second Amendment.
And the final amendment, I guess it would, I don't know where it would fit, but here's how it would read. In the event that the surcharge set forth in section 7-301C2 above fails to produce enough money to fully fund the Access to Council Fund, the Department of Housing and Community Development will provide the money needed to fully fund the Access to Council Fund.
Did you say that again?
Sure. I don't know where it fits. Heather will figure that out.
In the other bill, to look for funding, if you're just going to say, here's what we're going to do. And we just passed on the floor a bill that sets up a whole group that's going to say, look at funding, and now we're going to say, forget that, here's how we're going to fund it.
Well, because this is going to sunset in 3 years.
No, he's talking about another pot of money, though. He's talking about a permanent pot of money.
No, I understand that, but didn't...
No, I'm talking to Shelley. Yeah, Senator Heddleman.
Okay, then I misunderstood.
I'm a
All right,
little
you've got a
lost.
motion. There is no second.
A second, okay.
Creative solution, though.
All right.
Let's roll the bill.
All right. Motion is for favorable with amendment. Second. Let's do a roll call. Yep.
Vice Chair Waldstraker.
Yes.
On the entire bill.
Senator Lee.
Yes. Yes.
Senator Castle.
No.
Senator Heddleman.
Yes.
Senator West.
No.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
No.
Senator Carter.
Yes.
Senator Huff.
No.
Chairman Smith.
Yes. All right. Excellent. Passes with amendment. We are done for the evening. Have a good weekend. What? Oh, wait. What's going on? Okay. We doing that today? All right. Hold on one second. Hold on.
Our friend Addie actually has a bill, Chris. Just 1 minute.
All right. Which bill is that?
Senate Bill 955. I think it's Heather.
Senate Bill 955. Just give her a second to pull it up. 955. That's.
Yes, sir. Thank you, Mr. Chairman. I have a Senate Bill 607 that we passed out. We're trying to get the House bill to conform or to conform to the House bill. I think I spoke to Ms. Sandy earlier. House Bill 234.
Actually, the House bill is in the same posture as what the Senate conformed to. Or I guess the Senate receded. Yes. Let me pull that up. So the Senate version passed 47-0. It also passed the House 134-0.
It was unanimous out of the committee?
Yes.
Okay, so you just want to move the House bill, is that what you want to do?
Actually conformed. If you recall, it had to do with the interference of the service animal.
I think they're both in the same posture now, though, so
Right.
we just need to
Yes.
pass it straight.
Right.
Is everyone okay with that? Same vote as before? Okay, great.
Jimmy,
There.
what's the bill number?
That is House Bill 234.
So this bill alters the definition of a local government under the Local Government Tort Claims Act to include Cambridge Waterfront Development Incorporated in Dorchester County.
Is there any discussion on this bill? Just at least take a second to read it. But go ahead. Yes, Senator Carter, go ahead.
Please, I don't want to hold it up. Just roll it. I have questions because I don't remember the hearing. But why are we equating a waterfront development with a local government? I don't understand. Just basic.
Have to give if it was a government entity. So you're making it easier to sue them, actually. You should take away the notice
Go
requirement.
ahead. Go ahead. Get it, Heather.
To Senator Carter's question, so this is in the fiscal note. So in 2018, Cambridge City Council and Dorchester County Council formed CWDI, a nonprofit corporation responsible for the comprehensive planning and mixed-use redevelopment of the properties along the Cambridge waterfront. So CWDI advises that it currently budgets $1,700 per year for limited insurance. However, CWDI begins to acquire and develop property, which is expected in 2021. CWDI will have to purchase additional insurance coverage, property and general liability. And CWDI estimates that the initial expansion of its insurance coverage will cost $10,000 to $20,000. So being subject to the Local Tort Claim Act will also apply the caps under current law for this corporation.
Giving it the same tort cap as a local government. That's what it really is doing.
The effect will decrease CWDI's insurance costs and reduce its future exposure liability. The argument that they would make in favor of this is that they are performing a government-like service or duty by planning the mixed-use redevelopment properties along the Cambridge waterfront. But that is the counter argument.
Thank you.
Call on this? Okay, roll call.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
I think yes, but can you come back to me?
Senator Castle.
Yes.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
No, I mean, and to explain and listening to that, I'm not understanding why we're giving a cap to a private entity, so, no.
Senator Jackson.
Pass.
Senator Bailey.
Yes.
Senator Carter. No. Senator Huff.
Yes.
Senator Lee.
This is a nonprofit that we're talking about, right?
Heather.
Okay.
Are they a
No.
nonprofit? I think so.
I'm going yes if that's of any consequence.
Yeah, I don't know if they're a nonprofit.
Yeah.
I don't know if it's a nonprofit. It was created by Cambridge City Council and Dorchester County Council. Oh yes, it is a nonprofit. Sorry, corporation. Yes, it is a nonprofit.
Oh, okay. I just don't, I guess I didn't understand this, what this bill really does.
Hold on. You still have a question, Senator Lee? Do you need a second?
Yeah, yeah,
Senator Jackson, yes.
okay. Well, the bill passes anyway, right? Okay. Never mind. No, that's okay.
You keep your vote?
It doesn't matter anyway. Okay, yeah, just keep the vote, yeah.
What is your vote?
It was no, yeah. It was no.
What's your vote?
It was no.
No. Bill passes. That's their 10 times.
Here we go. I'm sorry. Go ahead, Senator West. At 10:30. We got one more bill here. I gotta get Chairman Judd here. Yeah, he's got it. Jamie's got it. Can you turn Jamie on?
Sure. Sandy, I just forwarded you an amendment for this one. This is House Bill 1186. This is the study on firearm crime injuries, fatalities, and crime firearms. In 2020, there was a bill that required OAG to produce this study. The bill extends the termination date from December 31st, 2022 to December 31st, 2024, and modifies provisions of the Act as it was originally passed. Specifically, it extends by 2 years the requirement that OAG study information regarding firearms crimes committed in the state since August 1st, 2015. Also, to identify specified information for each 911 request from emergency assistance involving a firearm crime, study information regarding firearm injuries and fatalities occurring in the state since July 1st, 2020, and with regard to crime firearm study, report, compile, collect, and gather information. The bill extends the dates by which OAG must report to the Governor and General Assembly its findings and conclusion regarding firearm crimes, injuries and fatalities, and crime firearms recovered, and requires an additional report with similar information. There is an amendment that should be going out shortly. And what the amendment would do is, so there's a confidentiality provision under the state's red flag law, but this allows, this amendment, it is, I'm not sure if it's gone out yet, but it's Amendment 823129/1. You don't have it yet? Okay. Right, so it creates an exemption for the confidentiality provisions for red flag and allows OAG to access the red flag information or the extreme risk protective order information for the purpose of its research under this bill. Right, so there's a confidentiality provision, and I'll just read it. It says, all individual identifying information reviewed and researched under this section shall remain confidential, and any report, study, or other use of the information shall maintain the strict confidentiality of any individual identifying information reviewed under the authority of this section. It does also provide that OAG may delegate the review and research undertaken under the authority of this section to a recognized research institution located in the state of Maryland.
Move adoption of the amendment. It's been seconded. Great.
We need a roll call on this.
Yeah. All right.
On the amendment?
Amendment's fine.
Here's a question. I have a question on the bill. when this went through last year, it was Office Attorney General. Somebody mentioned Johns Hopkins. Are they in this bill?
They're the one that, I think they do the research. I think it's the amendment. Professor
But they're not
Webster,
listed.
Daniel Webster. Yeah,
They're not listed in the bill, are they?
No, they're not.
The amendment puts Hopkins in this?
No, it does not.
That's that last.
I mean, I'm
part
gonna
that I
vote
read,
against it
though.
anyways, but if it's Hopkins, that's another negative on that. Well, I'm saying Bloomberg is the one that gives them all the money. He's a big gun control
Well,
guy.
it's not. It doesn't specify, but it says to share with a research institution.
But it is Hopkins because they've called me about it.
So is the amendment Hopkins?
It doesn't say Hopkins.
Well,
It
the
just-
amendment though says a research institute, which is them. So I want to be against the amendment.
Yeah. All right. So can you make sure that he's against it? Do you want to be against? Okay.
I want to amend it to Morgan State.
I would second that.
Actually, he's against it.
I'll take it anywhere that's not. Where do you want it? I'll take it anywhere that's not Hopkins.
All right.
All right. So the bill's before you as amended.
MSU.
That's what voting looks like on 7 o'clock on a Saturday, right before Saturday Sine Die.
One more bill to have Brian Frosch and Michael Bloomberg study gun laws in Maryland. No biggie.
And it's been seconded. So Senator West, are you ready, or do you need more information? Are you good to go?
You don't want to vote for this, Chris.
Motions were favorable. It's been seconded as amended with amendments.
All right. Favorable with amendments. Vice Chair Wildstreicher.
Yes.
Senator Lee.
Yes.
Senator Castley.
No, and just explaining, we might as well just write the report now because we know what it's going to say, but go ahead.
Senator Heddleman. Trudette.
I actually agree with that statement.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
No.
Senator Carter.
Yes.
Senator Huff.
No.
Chairman Smith.
Yes. Excellent. See you all at 10:30 on Monday.